audience, welcome to HETV program titled Zeidman Software Forensics and Safe on IP. Today, we are very honored to have the creator for this field, software forensics, Mr. Zeidman, to share the essence of software forensics, which is the science of analyzing software source code or binary code to determine whether intellectual property infringement or theft occur. Mr. Zeidman has developed the algorithms, technology, and procedure for code sweep, which has been used in over 100 cases worldwide. Mr. Zeidman has been a consultant and testifying expert on over 250 cases involving billions of dollars of intellectual property rights. Mr. Zeidman is the president and founder of Zeidman Consulting that provide engineering consultancy to law firms regarding intellectual property disputes. And he is also the president and founder of Software Analysis Forensics Engineering Corporation, SAF, which is the leading provider of software intellectual property analysis tools. He's also the author of the book titled The Software IP Detective Handbook, Measurement, Comparison, and Infringement Detection. Let's welcome Mr. Zeidman.
Hi, Mei-Hsin. Thank you very much for having me. I'm honored to be here.
Mr. Zeidman, you have been participating the case for Oracle American versus Google, testifying for the software infringement of Java API packages. Would you mind sharing your opinion and principles to decide the software infringement?
I worked on one of the most important software cases to date. I was an expert for Oracle in the case of Oracle v. Google. My team and I work for any client and we give them the best support we possibly can, whether we agree with their case or not. But in this case, I have to say that I strongly agreed with our client, Oracle, because Google had purposely copied code from Oracle without paying a license for the code, and I believe Oracle deserved to be paid. The history is that Sun Microsystem created the Java programming language, and it became one of the most successful computer languages of all time. Later, Oracle bought Sun. Google, at one point, wanted to promote its new Android operating system, and it wanted programmers to pick it up and use it very quickly. So rather than create its own APIs, its own connections to the operating system, it duplicated these application programming interfaces of Java that programmers already knew. Oracle had spent a lot of time and money educating programmers, and Google didn't need to. So at some point, Google was sued by Oracle over the copying of 37 specific APIs, and Oracle wanted $9 billion in compensation. Now, some people say, what's the big deal about 37 APIs? But actually, my team and I showed that those APIs, those 37 APIs, comprised about 11,500 lines of programming code. So this case went back and forth between decisions and appeals in different courts until the case went to the Supreme Court, which confirmed that the software was copyrightable. But it asked the lower court to determine whether Google's use of Oracle's APIs were fair use. So in US copyright law, someone can copy certain things without infringing the copyright. And those things have to meet 4 criteria. The first criteria is the purpose and character of that copied use. So for example, if it's used for teaching or news reporting, it's usually considered fair use. The second criteria is the nature of the copyrighted work. So in other words, if you're copying something that's educational, it may be okay to copy that. But if you're copying something that's commercial, that a company uses to make a profit, then typically it's not okay. The third criteria is the amount and substantiality of the portion being copied. And the fourth criteria is the effect of the use on the commercial market or the potential commercial market. So in other words, if a competitor copies your product or your code, in this case, and that means that you can't sell as many because now you have a competitor, then that would not be fair use. So this decision, this case, went to the U.S. Supreme Court, and I can tell you that the U.S. Supreme Court got it completely wrong. Their decision was completely wrong on every point regarding fair use, and it overturned 200 years of copyright law in the United States and 41 years of software copyright, because the Supreme Court declared that Google's copying of Oracle's code was fair use. Basically, the decision by the Supreme Court said that Google's use was so useful to the public because so many phones are sold with the Android operating system that it was okay to copy it. I believe that's like saying that if I come into your house and steal your television, and then I put it in the public square so that everybody in the community can watch, then it's okay, it's not theft. But US law has always said that that kind of thing is theft, that copying something that is copyrighted for commercial use is always copyright infringement. But for some reason, the US Supreme Court said in this case, it's not copyright infringement, it's fair use. Now, when you read a Supreme Court decision, there's often a dissent. Not all the judges agree. And in this case, at least 2 judges disagreed. And the Supreme Court, in its decision, also publishes the dissenting opinion. In this case, Judge Clarence Thomas, explained exactly as I've said, that the Supreme Court's fair use analysis, in his words, was fundamentally flawed. And he also stated that this order will eviscerate, again his words, will eviscerate US copyright law. I believe that he's exactly right and the Supreme Court got it wrong, and this will continue to have tremendously bad consequences for US software companies and software throughout the world. For one thing, all companies now need to keep their software code completely secret and never release it to the public, because once it's released to the public, there's a possibility that programmers can copy it and claim fair use. I believe it may also hurt the open source community, because open source code is protected by copyright law. A lot of people don't understand that open source code has a copyright in the United States, which means that the producers of that code are allowed to give it out under conditions that they set. And so right now there are license agreements for open source code, and programmers must abide by those license agreements. However, if copyright law does not protect that code, if it's fair use to copy it, then open source code can be copied and the license can be violated with no consequences. And the other concern is that independent software developers and startup companies can now, according to this decision, have their code copied by big tech companies, because big tech companies can distribute the code worldwide and benefit many people. And essentially the US Supreme Court's decision states that if it benefits a lot of people, then it's fair use. So we'll see the consequences of this moving forward. I think it's a really bad decision. US Congress has the ability to overturn this decision by writing a new law that clarifies fair use of software. But until then, I think software development will actually suffer.
Thank you, Mr. Zeidman, for your precious insights. You also have considerable experience on dealing ITC cases, such as Nidro versus Samsung, Microsoft, Amazon, Lenovo, Motorola, Dell, and HP. So would you mind sharing us the difference for handling the case between the general court and international trade commission cases?
It's an interesting question about the difference between bringing a patent case in front of a U.S. federal court or the U.S. International Trade Commission. One difference is in federal court, the parties can decide to be heard by a jury of 12 US citizens or by just a judge who makes a decision. In the ITC, the International Trade Commission, it's always just a judge who makes the decision. That can be a positive or a negative. But the other thing is, I would say that probably the International Trade Commission favors US companies. I say that not based on any statistics, but knowing that the ITC was set up to prevent products being imported into the United States that infringe a US patent. Now, foreign companies can get US patents, and American companies usually manufacture their products outside the US. And so the ITC can rule against an American company or against a foreign company, but in any case, a ruling by the ITC of patent infringement means that the product will be barred from coming into the United States. Now, there was a famous case in federal court called eBay v. Merck Exchange. The decision is often referred to as the eBay decision. But before the eBay decision, in a patent case in US federal court, if a product is found to be infringing on a patent, the courts can rule that that product that infringes cannot be manufactured. So that was an injunction against manufacturing an infringing product. But in the eBay case, the Supreme Court found that they believe that that's too extreme a solution. So it's very rare that a patent infringing device will ever be barred from being produced. In other words, it's very rare for a patent holder to get an injunction against an infringing device. So now that injunctions are gone, large tech companies that infringe a patent can continue to manufacture and sell the device. And that means while they're selling the device, there's very little harm to the big tech company. And they can continue appealing the patent infringement ruling all the way up to the Supreme Court. And this can take years to resolve and lots of money, which big tech firms can afford, but small inventors and small companies cannot afford. For that reason, in some cases, going to the ITC is advantageous, because if patent infringement is found at the ITC, that means the infringing product cannot be imported into the United States at all, which means that even if a large tech company loses at the ITC, they can no longer import the device and they can no longer sell it in the United States, which means a good ruling for a patent holder in the ITC will lead to serious negotiations or serious settlement talks between the parties, because no company, no matter how large, wants to risk any kind of inability to import or sell its products in the United States.
Thank you again, Mr. Zeidman, for your comprehensive explanation and sharing. See you on our next program. Dear audience, please do come back next Wednesday at 1 p.m. for Zeidman Software Forensics on SEF on IP on HGTV. Do not miss the opportunity to sharpen your skills and enhance your proficiency for career competence.